Sarah Boone is at it again, and now she wants the murder case against her completely thrown out. All this comes after a slew of attorneys resigned from her case, and now she's representing herself. So this same woman, who's accused of zipping her boyfriend into a suitcase and leaving him there to die, is now the one who filed this new motion, arguing her constitutional right to a speedy trial has been violated. So we're bringing in criminal defense attorney Kaysia Earley to break down this new motion and look ahead to Sarah Boone's looming trial. Welcome to Sidebar, presented by Law&Crime. I'm Gillespie. By now, you're probably familiar with the case of Sarah Boone. It's captivated our audiences for more than 4 years now. It takes us back to February 2020, when Boone was hanging out with her boyfriend, 42-year-old Jorge Torres. She says they were drinking and playing hide and seek, as one does, and Torres climbed into a suitcase. Boone says it was all fun and games, but take a listen for yourself.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Boone says she forgot about Torres and the suitcase and went to sleep. She only woke up hours later when her phone rang, and that's when she says she found Torres, who then was unresponsive.
I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole, knowing that it's there. He'll get out and no come. Because you don't.
And then he doesn't, but you don't go check on him. You say you're up for 30 minutes, and he doesn't come up. You don't go down and check on him?
I'm in the bed.
So after all this, Boone is arrested and charged with second-degree murder in Torres's death. She's booked into the Orange County Jail in Florida, and that's where she's been ever since. The case has seen some movement, though. She's gone through 9 different attorneys and written hundreds of pages of letters to her case's judge, demanding new counsel or even simply complaining. So all that leads us to where we are right now. Boone is representing herself. Her case is set to go to trial in October, and she wants it thrown out. So now let's break down this new motion and see if it'll hold up. For that, we turn to criminal defense attorney Kaysia Earley. Hi, Kaysia. Thank you so much for coming on with us today.
Thank you for having me.
Okay, Kaysia, we're going to start with the right to a speedy trial. This is something everyone knows about, but I do have the Florida state statute up. And it says a defendant has the right to a speedy trial 90 days after their arrest if it's a misdemeanor, or 175 days if it's a felony. Now, we know it's been more than 4 years since this alleged crime happened, but now Sarah Boone is saying that she wants this right to a speedy trial, and also she wants everything thrown out while we're at it. What do you make of it? Does her argument hold up?
It does and it doesn't. The problem with her motion, and I actually printed it out and I reviewed it. The title is right, but the body is wrong, because in one instance, she's asking for the case to be dismissed. So she filed a motion to dismiss. And then in a body, she's claiming ineffective assistance of counsel, and she wants a speedy trial, which she attached as a Sixth Amendment. So these are several motions into one. And had she wanted to file a motion to dismiss, claiming that, the charges were legally defective, she should have filed that under the Florida Rule Criminal Procedure 3.190. Now, for the speedy trial, just like you mentioned, this is a felony, and you have 175 days, which, by the way, was already waived because obviously she went through so many attorneys. But she does have the option of filing another demand for speedy. Then she'll get a 5-day hearing, and trial will be set within 50 days. But she filed it under the wrong motion, and that's what happens when you're pro se.
Okay, so let's talk about her motion, because as you mentioned, she is now representing herself, and that makes for an interesting motion to say the least. And to start, she kind of makes a dig at her past attorneys, 9 of them, and I wanted to read it verbatim. She writes, quote, "Ineffective," which is not a word again, it's ineffective, but I'm reading what Sarah Boone wrote. "Ineffective substandard state-provided attorneys should have made this request long ago, proving this is a fact. about the right to a speedy trial. Does this argument hold any water, though? Because it seems like she's asking for the speedy trial, but then this is ineffective use of counsel. So what do you think?
Not at all. Because typically you see ineffective assistance of counsel with appeals. So basically, if I had an attorney and I was found guilty, and I believe that that particular attorney did not file the proper motion or say the proper objection or allowed evidence in that should have been excluded pursuant to the Florida rules or the rules of evidence, then you file the appeal, and one of the appeals would be ineffective assistance of counsel. But her case is still pending in trial court. So, even if you have a legal basis, you also need to back that up with legal authority. Legal authority is case law, and that case law must be shepherdized. And shepherdizing case law, you're essentially making sure it's still good law, because sometimes cases are overturned, they're red flagged. So there's so much that should have been placed in this motion, and it was not. Therefore, I'm confident that the judge is going to deny this motion, and she's going to have to file it in a proper way. This is why it's absolutely important to have proper legal representation and not represent yourself.
Hey, so I'm going to take a guess and say a lot of you who watch our videos might be business owners, maybe even thinking of starting a little side hustle. Well, that's why I want to talk to you about our sponsor, Odoo. Odoo is a free all-in-one business management software that provides you with a range of applications that help with the day-to-day of owning a business. So say I wanted to use one of their application tools, like their website builder, to build my own site. I could seamlessly, and did I mention for free, build SierraGillespie.com with Odoo that features all my top body cams and more with little effort. Thanks to Odoo for sponsoring our videos and getting me my own website. You can build your own website now. The domain is free for the first year when you use our link, odoo.com/LC-Sidebar. I think it's interesting that she wants a speedy trial now, given that her trial is set for October, so just around the corner. But this happened back in February of 2020, so 4 years ago. And during that time, she's gone through almost 10 attorneys. So it seems to me she was kind of slowing it down herself. I mean, we saw those letters. She wrote the judge hundreds of pages, handwritten letters, mentioning that she wants a new attorney over and over and over again. So why now is she saying, hey, I want the speedy trial, when in the past it seems like she was kind of dragging her trial out?
Well, it's essentially looking at this case from the beginning. It's clear that she's being represented by assistant public defenders. By the way, I used to be a former assistant public defender, and we're real lawyers, right? So we have to go to law school. We have to pass the bar. The only difference between being a public defender and being a private attorney, we have more cases on our docket. And I believe from the onset, Sarah Boone was just being unreasonable with her request. She believed that she should have been the sole client and taken care of, given preferential treatment, and that's not how it works. And I do believe she had some great attorneys that was willing to fight for her. But sometimes I always have to explain to my clients, I represent your legal interests. I am not your puppet. So sometimes we're going to disagree with the theory of defense. We're going to disagree with what evidence comes in and goes out, because I was schooled and trained in the proper way of practicing law. And you have your feelings, and we talked about this. We always say that if you represent yourself, you have a fool for a client, because you don't know. We make it look easy, but what's the purpose of us going to law school, studying for the bar, and learning about all of the legal procedures, the statutes, case law, for you to think, oh, I can do this. So, she's climbing an uphill battle. It's going to be extremely difficult. And there's no way that she's going to have any traction on this motion. Denied.
Okay, so one of the reasons we wanted to talk to you today is because of your past as a public defender. Our booking producer, Alyssa Fisher, who we couldn't do the show without, but she mentioned that you had a defendant in the past who was kind of reminiscent about Sarah Boone. Is that right?
Of course. I had several defendants in the past, primarily maybe because I'm a female and they think that, we're nurturers. But no, I'm a zealous advocate for the law. I respect the rule of law. And there were times that my client wanted me to file a demand for speedy, and I didn't even have discovery yet. And I understand you're in custody. You think you have a great case. You think you have a great legal defense. And I have to have these serious conversations with my client and let them know I'm not prepared. But if you really want to go forward, you have that right. But the problem is that if you choose to go forward knowing that I'm not prepared and you still want to go to trial, you don't want me to investigate further, set depositions, or even see if there's any evidence out there that can prove your innocence, the difference is you run the risk of losing your freedom and I'm walking out of that door. So oftentimes when I have this conversation with my clients, reality check, they come to their senses. And then there's other times where there's not a connection there and they're fighting me. And as a public defender, you're assigned to those cases. It's not like I can just withdraw because, I don't like you. But if there's an issue, sometimes I may even request mental evaluation just to make sure that this person has the right state of mind. So sometimes that works, and sometimes, they just have to go forward with trial and eventually be found guilty.
And we know that it was both Sarah Boone who was asking for new public defenders, and some of them were motioning to get off the case too. So it kind of seemed like a mutual situation. And that's how we ended up here that we're talking about today, the motion that she herself filed because she is representing herself. And I wanted to go back to that because this was kind of crazy to me. When I opened the motion, I didn't expect to open a history textbook. She literally has the Bill of Rights. Yeah. She's talking about, she has the second one talking about the militia, the right to bear arms, obviously irrelevant in this case. Was that a little unconventional to you too, seeing the entire Bill of Rights right there?
When I saw this motion, I just immediately went into lawyer mode. I wanted to see case law. I wanted to see a legal argument. I want to see a summary, a history, so that I can shepherdize and be prepared. But when I saw it was just a copy of the Bill of Rights, I'm like, no, this is not good. There has to be something on the third page. Yeah, it was a copy of the envelope that she mailed to the court. So clearly, she does not know what she's doing. And I can't figure out for the life of me, as a practicing attorney who's tried over 100 trials and represented thousands of clients, I don't understand how someone, a pro se litigant, can feel like they can do this and gamble with their freedom, because this is not civil law. This is criminal. Your freedom is on the line. And if you lose, and most likely you will lose, because statistics show that if you represent yourself pro se, you have a greater chance of being convicted versus if you even have a public defender. And public defenders don't even get that much respect because they think, oh, they're public pretenders, they're not real lawyers, they don't care. There are great public defenders out there that will uphold the rule of law and zealously fight for their clients. But then you have clients who are being unreasonable. In this case, Sarah, you did it to yourself. You did it to yourself.
As far as this motion, we've hinted at it a bit before. It doesn't seem like it's really going to hold up. So what do you expect the judge's response to be?
Well, first and foremost, the judge must respond. Although this is, not considered a legally solid motion, the judge must respond for purposes of the docket, purposes of the record. So most likely this will be a denial, and she will respond in writing because this was not an or tennis motion. She did not make this motion verbally, and the case will go on because, again, she can't have a speedy trial because she has to file it under the proper Florida Rule of Criminal Procedure. And then there's a purpose to it. You have to have a 5-day hearing after you file the motion. And then once you have that 5-day hearing sets the trial date, which is set within 50 days. And if she's not tried within the 50 days, there's a 10-day recapture period, which is a notice of expiration that she also must file. And then if she's not tried within that 10 days, the case gets dismissed forever. But she's not going to know this because she does not practice law. And besides, even if she did know all of that, she doesn't really have a good legal defense. We all know the facts of this case.
So we're thinking that's what's going to happen. The judge is going to dismiss this. And then, as we've talked about through this entire interview, she will represent herself. She is pro se. That is coming up in October. And I know I'm very eager to see what she has up her sleeve, if anything. What do you expect to see?
Circus involving Sarah. She's going to not know how to pick a jury. There's a certain way that you pick a jury. And can you imagine you being the defendant, questioning the jury that will potentially make a determination as to whether there's guilt or innocence? She's not going to know what to do. And let me say this, although we have the right, the constitutional right to represent ourselves, We don't have the right to be nurtured along the way by the judge and to learn the law along the way. So the judge is not entitled to say, hey, Sarah, don't forget you got to do this. Or the prosecutors, they're still going to object. You can't have hearsay. It can't be inadmissible evidence. So, what do, Sarah? Do you humble yourself and say, Your Honor, I would like to have an attorney, and this time I'm going to let them lead and I follow? Or are you going to still be belligerent, rude, disrespectful to the court, and make these demands that you're not entitled to under the Constitution, the very Constitution that you attach to your motion? So it's going to be very interesting, to say the least.
Well, if that does happen and Sarah Boone says, I am in over my head, I don't think I can do this, hey, judge, I actually want a public defender, what do you think the judge is going to say? Because this trial has been moved back so many times, and it seems like they want to go forward with it in October. Is it possible that the judge just denies that and says, okay, Sarah, sorry, this is where we're at?
Well, typically what they do if you're a pro se litigant in a criminal case, you represent yourself throughout all of the duration of the trial. But once you get to the jury trial, you have what's called a standby attorney. So they're off to the side, but once you call them in, they're willing to help. But the problem is they was off to the side the entire time, so they don't know what you've been doing. There's not a meeting of the minds here. So it's still, to me, ineffective on her part, but not, it wouldn't be an appellate issue because you did not want that previous attorneys that you had in the past. And a bell should go off in her head. I mean, if you had 8, 9 attorneys prior, clearly the problem is not the previous attorneys. You're the problem. But she's not willing to accept that.
So we've talked about Sarah Boone's defense, whatever it may be, we'll see. But for the prosecution, I'm thinking they might have, I don't know if I want to say an airtight case, but a strong case. I mean, this happened February 24th, 2020. We're more than 4 years since this happened. Would that give them a lot of time to go through all of the evidence, all of the details, and really fine-tune their argument?
It depends. My experience as a public defender, prosecutors don't stay on the case the entire time. Oftentimes, they're transferred to different departments. They stay in one particular department, let's say a year or two. So we don't know if this is the same prosecutor that was on the case from the inception. However, they already have the upper hand because they're skilled and trained in the rule of law. They're knowledgeable attorneys, they're experienced attorneys, experienced trial litigators. So they already have the upper hand. But just to see it, put on my defense attorney's hat for a moment, if I was forced to take this trial and be standby attorney for Sarah Boone, I would try to say, he zipped himself in the majority. He was willing, he assisted. And although I didn't take him out immediately, it was a game that he complied with or whatever the case may be. But that's pretty much her defense because intoxication is not a defense. Voluntary intoxication in the state of Florida is not a defense. So she can't say, well, I was drunk, I didn't know, unless she's going to blame it on him or he forced me to drink. But you can tell by the video, the cell phone footage, which she created, and it's the most harmful evidence against her, that she was mocking him and he was pleading for his life at the same time taking his last breath. And I think that is going to be compelling evidence to the jury, and that will secure a conviction.
Whatever happens, we're definitely going to keep an eye on it to see what Sarah Boone brings to the table and what the prosecution does too. Kaysia, it's always great talking to you. Thank you so much for coming on.
Thanks for having me.
Boone's motion to dismiss was filed just this week, so we're just waiting to see how the judge rules on it. And for now, her trial is still scheduled to begin on October 7th at 9 a.m. You can follow the entire thing right here on Sidebar, where the one and only Jesse Weber will break it all down. Now make sure that you don't miss it by subscribing to Sidebar anywhere you listen to your podcasts, whether it's Apple Podcasts, Spotify, or YouTube. I'm Gillespie, and this has been Sidebar, presented by Law&Crime.